All right, a little bit of housekeeping. It's just want to clarify a few things that I had said in the video to help us give us again some more deeper perspective of what I am speaking about and not fully, you know, denotatively extracting that information out because, obviously I can't be speaking to every little sentence and every little matter and explain it because, of course, the videos would go on forever. So there was a point here I made and I want about capital money and I want to make a clarification on that. So best way to do that is play it and then show you what, and then of course refer to it in relationship to getting that clarification understood. Into the court or into the hands of trustees. The Act of 1882 and the subsequent acts ought then to be construed by the court with regard to those broad principles and in spirit of wise and reasonable liberty. Don't think we need to go into much of that last little thing, except guess what happened? They went from the land and then changed it over to purchase money, so that would be the capital money. The reference I want to make here is when I said land to the purchase money and then I added that is the capital money. We need to get some clarification on that. There's two types of capital money. The one that this is speaking to, this particular article, in that once land was settled and was able to be transferred, the legal estate, into a trustee, into a trust, then those who wanted to purchase rights to the equitable use of that land will be classified as using the capital money in which the trustee would hold for the benefit of the tenant for life. But if we're speaking to the capital money that is subject to the strict settlement, that is, which is tightly controlled and annexed to the land itself. Essentially, the land right is also the capital money right. And they're not separable. They are one of the same thing essentially. And even though money is a movable, it becomes an immovable once it is attached to the strict settlement. So I wanted to get some clarification on that, and let's move on to another point. So to be clear, there's the capital money that we're interested in initially because it belongs to the legal estate that was created at our birth. That is annexed to the land. The capital money that is made through purchase under the trust is a different matter altogether. And of course, we have no direct interest in that matter inasmuch as that is what the trustees are in charge of, and then we deal with the trustees in order to determine what our legal estate is and what is owed based on whether our time and so forth and whatever those measurements and formulas they use in order to make that discernment is that amount that is owed to us. But again, that is for the trustees in the court to make that decision, not for us. Again, we are just the ones who hold through our life the legal estate. So let's move on to this other area for more clarification. So I got two most of the here. Living in trust for any persons by way of succession. Okay, now I watched the video after and I noticed that I brought up the rules of succession, or what a succession means, and I'm going to deepen that a little bit, but I didn't go into living in trust for any person in possession. What I should have done is stop the succession point, and you'll understand as you go through the video, stopped it and then started the possession point, which is having possession of the fee simple, of the life estate, or of the entail once you actually are holding that land interest. Okay, now you could hold the land interest in possession if you're holding the entire estate and then you carved out lesser estates like the life estate and the entail, you carved out other lesser estates from that point on, you still hold possession of the entire estate, which then holds that life estate and that entail. So you're always holding that, and that's why reversion comes into play and has to be in play for the basic foundation that, as we've already determined, no land can be held in abeyance, and as such it has to be held in somewhere in some title, and no matter if it is something that's not yet possessed, like a future interest, those interest in expectancy through the device of remainder or reversion. We'll get into that in the next video, I believe. But we hold the entire estate, the legal estate, to which when there is a lesser estate carved out from it. So let's say G, you being grantor, you then grant a life estate to A, and then A holds a remainder interest for the benefit of B. So each one has to be pre-existing in order for the other one to be affected. And if for some reason it doesn't get transferred to B properly, let's say there's a contingent remainder on it, meaning that, well, when B reaches age 21, and if A dies and B doesn't reach age 21, well, through the action of reversion, it goes back into the grantor and his heirs, and that's how you can see everything's always connected. Everything has to revert back to something, or it has to stem from something, but it can never just be held in limbo. So back to what I was speaking to in relationship to succession. Succession is just a time value. It's that more or less the rights of a land interest to succeed. And generally, when we're talking about the common law legal estate, that's the laws of inheritance. And generally, it was predominantly the male that was the first male that inherited. And then it was, well, if that male wasn't around in order to accept that estate interest, then there was always a different right, whether it might be the second male, or it could be the first daughter, or it could be sometimes even the chattel interest later on that came into fruition, which would be those rights like in uncles and aunts, those people that weren't right of your own direct bloodline, but of your father's bloodline or your mother's bloodline and that sort of thing. And I don't want to get into that because that becomes a whole new kettle of fish, and we have to deal with chattel interest and how that all worked out. But essentially, when we're working with the common law legal estate, we're dealing with succession through the laws of inheritance, and succession is then measured through what life or what estates are created therefrom, and those estates are relative to the laws of expectancy, of future interest being reversion and remainder. All right, let me do some housekeeping. I want to nail home tenancy. So what I'm going to do is just going to go through the different types of tenants. All right? Because if you don't have this, if you don't assimilate this, then everything else is going to be hard for you to discern where your obligations rise and how everything's all structured. So tenancy is paramount. So that's what I want to spend some time on here. And then we can move on to more matters, the Settle Land Act and so forth, which created and established the duties and powers of the tenant for life. All right? Okay, tenant in captive, the holding of land in feudal tenure direct from the monarch. Okay, now when William the Conqueror, AD 1066, brought in his laws based on the Norman laws, there was one problem which what the French had, and that was that they only put their attention to those ones immediately, like of the king. So it would be, I'm only going to give the common law to the barons in as an example in English law. So the French would say it's only those who have an immediate interest, and I'm only going to deal with them. The problem is that because the French king didn't have a relationship to who those knights that were in charge with all the other knights, then those lower knights, so it would be equivalent to the baron and then his knights, his army, would then go wherever the baron went. So they didn't have that direct allegiance to the king. They had more allegiance to the baron or their general, if you want to call it that way, for lack of a better word, just say the general, the knight. That's their allegiance was. So the king didn't have the full allegiance that he needed for him to grab or to hold a peaceful kingdom, in as much that if the barons got pissed off, well, then they would just get their armies together and overtake the king. So it wasn't a very good system. But when William the Conqueror, AD 1066, took over, he realized that, and therefore he gave common law tenures to not only the barons that were immediately under the king, but he also did the same thing with the lords. So they were accountable in the common law, so that means they also held a tenure. Thereby, that allegiance would now cascade into the king being the only one that where or who would have the true allegiance, where these knights would hold their true allegiance in, as opposed to following the baron. So we got here, we're talking about right at the offset, that tenure was immediately under the monarchy, and you were a tenant. Let's go to next, tenants in chief. And we go into, in medieval and early modern Europe, the term tenant in chief or vassal in chief denoted a person who held his lands under various forms of feudal land tenure directly from the king or territorial prince to whom he did homage, as opposed to holding them from another nobleman or senior member of the clergy. The tenure was one which denoted great honor, but also carried heavy responsibilities. The tenants-in-chief were originally responsible for providing knights and soldiers for the kings in the feudal tenure. So right off the cusp, it didn't matter what status you had under the origins of English law and the land or the feudal land tenure system, you had to be a tenant. Why? Because all land is cheated back to the king. The king was the primary owner, the one that had royal prerogative over all rights to land. Therefore, you could never be absolute owner when it came into the feudal land tenure system, to which then filtered into the system that we are now dealing now. It is all the same thing. It's still a tenure-based system. Okay, just some of the names have changed and how we associate them, but you had to be a tenant. And let's further go into another definition: the tarry tenant. He who is literally in occupation or possession of the land, as distinguished from the owner out of possession. But in a more technical sense, the person who is seized of the land, though not in actual occupancy of it. So there you go again. There we have that sort of that landlord-tenant agreement, to which now the lords held the superior tenancy right, but to those who were underneath them, they were their tenants, and then they held certain responsibilities under the lord. Copyhold, okay? Copyhold is one of the three main forms of land ownership found in post-medieval period. Freehold corresponds to the ownership as we now know it, and leasehold refers to property held on a lease for a fixed period. Copyhold was somewhat similar to leasehold, since the property concerned belonged to the lord of the manor in which it was located and was held from him by the de facto owner. It had developed from medieval customary tenure holding according to the customs of the manor, because changes of ownership were made in the manor court and recorded on the manor court rolls. The new owner received a copy of the entry on the roll to prove his tenancy. And blah, 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 blah. So again, there we are, the other layer of tenancy. Villenage, a more thorough explanation. Villenage is a historical term that refers to the type of feudal tenure in which a tenant held property through servitude to the feudal lord. The tenant was obliged to render base services to the lord, which could include agricultural work, carrying out tasks around the lord's estate, and other duties as commanded by the lord. So it was a duty that was classified as the tenure, and then that established the type of tenant that was available for that copyhold. And then from that point, what happens? We go down into lesser and lesser rights, and peasants and serfs and slaves, okay? So again, tenancy was of either the baron and the lord immediately under the king, and those that were immediately under the lord were tenants that held other titles such as copyholds in order to prove their allegiance and their rights to hold that interest under the feudal land tenure system. Okay? Yale Law School, Statute Edward. Why I want to bring this in is the quia emptoris. Quia emptoris was essentially that those tenants under the lords became landlords in themselves when they then sold or granted a lesser right or a lesser estate to someone under them. So they then became the tenants, and it became known as sub-infeudation, which by the lords would then have certain agreements with the tenants, and then the tenants would then give certain rights to those under them, to which then created another title or another tenancy, to which that tenant then, who hold the equal interest under the lord, would become the landlord. Okay? So let's just read from here. For as much as purchases of lands and tenements of the fees of magnates and others have many times previously entered into their fees to the prejudice of the same lords, since to them, the purchasers, the free tenants of these same magnates and others have sold their lands and tenements to be held in fee for themselves and their heirs from the subfeudators, and not from the lords in chief of the fees. So again, because it was a tenant and a different agreement that the tenant held under the lord, that when he made a new agreement, as I've already said, then that had nothing to do with the lord in chief, because again, it was not an interest that was of the lords and chiefs, but it was only made of the tenant. And the statute of quia emptoris 1290 stopped that. So what essentially happened is that if any tenant gave any lesser right to a lower party, to which then became a tenant, the before tenant lost his rights to that interest, and the fee that was originally owed to the lord was now instilled in that new tenant or that lower tenant. So that's how that interest evolved. So now I want to put this to rest. We have to assimilate this, okay? This has to be completely inner and understood. However you want to look at it, you might not like the idea of being a tenant, but let me just go on here, and then we will make a final point, and that is, in consideration, if all tenures began in rights of tenancy, and lords are still subject of the monarchy, but no longer subject to a fee, which was the Abolition of Tenures Act 1660, and as such, those lords temporal still hold these strict settlements subject to common law rules of inheritance, now we can see how it is impossible for anyone to get rid of or to circumvent the idea of tenancy. It is impossible. Okay? Now, if anyone's trying to explain to me and the law, how is it even possible that those estates created under these lords, those estates managed by commons and territorial governments under these strict settlements, somehow eliminates tenancy altogether, and then next citizens somehow hold land superior to those held by temporal, while they are performing through purchase under commons? Lords create tenants under them in equity, no other way, as we also see here in the Statute Quiam Taurus. The lords had tenants, and then those tenants created other tenants, okay, to which was abolished, as I've already spoken to. English law is simply a hierarchical system of landholding. How do we know this besides just comprehending the evolution of English law and equity? For the very simple, basic, immutable, and denotative fact that the law does not ever allow land to be held in abeyance, meaning all land, which are just rights, so not traditionally soil, namely of the earth, and so must be held in some person through status and subject matter. Once known, then established jurisdiction for the courts to act. That is what English law is. It affects and so controls rules of action over the use of land, to which people become obligated to take care of their noticed land interest for the benefit of society. This is Obligation 101. One cannot ever escape English law or equity unless they either surrender their legal estate through express agreement, and so the tenant position. Until then, it can be an applied agreement via actions, or the individual is no longer abstaining from exercising their rights, use the duty and power of a tenant for life, namely, and if the trustees are unnamed, then that tenant for life must go to court to be assigned those trustees in order that they can then vest that legal estate and no longer be subject to the position of a tenant for life. Every person, and you all know that a person includes a corporation, is obligated to perform a duty subject to the current agreement noticed through their very own actions within a society. Now let's just go to Wikipedia for some foundational meaning and the scope that encompasses every obligation establishing the fundamentals of a society. See here, I pulled up Reception Statute. Okay, we start here. A reception statute is a statutory law adopted as a former British colony becomes independent, by which the new nation adopts, or receives the English common law before its independence, to the extent not explicitly rejected by the legislative body or constitution of the new nation. And I sort of bastardized that. Let me read it in one full sentence, okay? A reception statute is a statutory law adopted as a former British colony becomes independent, by which the new nation adopts or receives the English common law before its independence, to the extent not explicitly rejected by the legislative body or constitution of the new nation. Reception statutes generally consider the English common law dating prior to independence, as well as the precedents originating from it, as the default law, because of the importance of using an extensive and predictable body of law to govern the conduct of citizens and businesses in a new state. So, this is another thought to get across to your own mind. When I dealt with the Attorney General here in the province of British Columbia, he kept on deflecting his duties and throwing them on to the Legal Services branch and the Deputy Minister's branch, but he never transferred the duty, he just deflected it. So I had to discern, well, seriously, what does the Legal Services branch and the Deputy Minister's right have according to my own legal estate and my own interest, based on the parameters of the Settled Land Act 1925 as it is held in me as the warranty I use in order to have that legal estate vested. Okay? And all the legal services branch, again, it's a government branch, so they have no rights whatsoever to deal and muddle in your affairs. Okay? They would always come back, British Columbia and Canada doesn't recognize the Settled Land Act, blah, 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 blah. Okay? Well, and here's a question you can put to your countries, respective countries, those territorial governments, and as such, did your country ever put in a statute that eliminated the Settled Land Act 1925? Guess what? The answer is a resounding no. So thereby, by this very understanding of reception rules and the reception statute, then they've accepted it by not rejecting it. And isn't it funny, though, when I talk about people going, how do I get obligated? How do I become a tenant? And they keep on going on, and they're doing everything that a tenant is supposed to do, not realizing it, is that they then, one moment here. Sorry, I had a little emergency there. That the same concept, exactly the same concept applies to you. If you haven't done and no longer abstain from exercising your rights, as pointed out in Section 106 of the Settled Land Act, then the law continues through an implication that you've made that agreement. So it is you that has to stop it. Just like what it says here, reception rules. If your territorial government did not create a statute that eliminated any part of the English law, then that English law still applies, regardless of what they then create thereafter. Okay? All English law is in effect unless it has otherwise been rejected by the territory through the exercise of law. Yes, United States of America, you are subject to English law by the very fact you developed all your case law from its foundation. So are independent of the Crown, but not the English judiciary, which then governs your territory. Law does not mean Crown, but it means the laws held in the monarchy, who is the only non-tenant. So if you're thinking that you've gained independence from the Crown, yeah, but you haven't gained independence from English law for the very fact that you use English law. So as the Settled Land Act 1925 apply to you as an individual? I'll let you have that percolate for a little bit. The common law land interest has to be held in some title. Has to. And so by being subject to English law is how the USA will be forever tied to the British monarchy. To the extent each individual has to have a right to the law because they are agreeing to hold a tenancy initially, and thus with rights before the government, since a tenancy originates through a life. In order for society to work, there has to be rules of action, either expressed or implied, by each of our own actions. So we have to stop being thick-headed thinking otherwise. While we are emphatically demanding government and the judiciary to be responsible to their obligations, we must also be responsible for our own. Namely, if we are affecting these obligations upon others, means the measurement used will always be to the extent of the debate, and so the subject we are referring to. We must become responsible and know what are our obligations when we then try to enforce obligations upon others. Quid pro quo. Okay? So let's stop being a whiny child, including attending protest while us using "we are a living being" and demanding our dessert when it has already been decided that before we can even have dessert, we must eat all of our meal. If we are fighting for dessert, namely, means we have agreed to the meal. Fuck me, man. All I now see in the freedom and sovereign movement is a sea of ignorance concerning what law is. In the same moment, they want to use the law to enforce the right to be noticed within it. So naturally, it must be a tenant, so as to have a right of action within law and equity. Evidently, each is agreeing to be a tenant, subject to the status of a legal personage, and so are thereby proving they are now performing an obligation subject to law and equity. You cannot escape tenancy, as that is the requirement to be considered with right under English law. So you have obviously an obligation. My God, it is not more simple than that. Have I drove this point home? Ignoring the room in the elephant inn is no more anyone else's folly than ignoring that there is an elephant in the room. Each individual must be held to be responsible for their very own actions, or we return to pre-law and the total raping and pillaging through anarchy. The point that must be assimilated before any one of us can essentially be fully responsible is to begin to comprehend law and equity. Equity follows the law. It follows the strict settlements held by lords, and before this, all held in one single title called the Monarchy. The Monarchy, since 1688, holds the land in confidence as fideicommissium. The Monarchy can do no wrong because it is the paramount title that holds the land in trust for the people through the law that has been already settled. And people are never in this position with complete dominion rights, because through their very own actions are affecting an obligation necessary in society, so that within it, people, so let me just see what I got written here, so that within it, people have redress according to the interests they hold, so that the realm can restore the peace subject to the action of each individual through the law and equity. Right now, each one of you holds, like through citizenship and your passports and the land you hold and secured in that subject when it's measured against all other subjects of the same. So that's what you're doing. That creates the obligation. You're wanting to be secured within that right, in that interest. And then, at the same moment, what you're doing is saying, okay, where am I obligated to then perform all these duties that I'm asking everybody else to perform? Okay? We have to make it simple. It's not that difficult. Common law, I was actually going to go into another part here, but I see it's 32 minutes. We will now go into the expectancy, reversion, remainder, or possession, and carry on into the Settled Land Act. Please like and subscribe and share. And thank you everyone for your donation so far in learning what law is, because this is your true and only resolve if you want complete freedom, if you want to stand on the earth, on the soil as a man. Now you have to be 100% responsible, and the law and equity is only going to see you to the level of your own comprehension of what law is. They're not going to give you, give you the entirety of your legal estate until you ask for it. Okay? And you're only going to be treated subject to how you hold things, because that's the only way that they can deal with it, because you're asking for redress and remedy subject to that interest. So bring in the proper law, command the proper court, learn what law is, and then get it done.